Okay, folks, we have to talk about this Supreme Court decision today dealing with the Trump administration trying not to pay billions of dollars out the door pursuant to the Usaid program. There's a lot of misinformation, in my opinion, out there about what this order said and didn't say. And I want to bring you up to speed on this because to make you the smartest person in the room on the Constitution and the Second Amendment, we sometimes have to get geeky on some of the procedural items. And what you read on X and what you read by certain people may not always be correct in my view. So I want to sort of tell you how I see this case, what the Supreme Court decision says, what it doesn't say, and why I don't really think we, Trump supporters or Second Amendment supporters, should be freaking out just yet. Let's talk about it. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America, the 2025 Gundies Awards. Thank you so much for your support. I hope to continue to earn your goodwill and your support and your viewership. Okay, folks, so we got to talk about the Supreme Court order. It's not specific on the Second Amendment, but it really is. Because, of course, as we've talked about, we want to make sure that our government, our federal government, our politicians are acting in a constitutionally correct way. Because if they start to ignore certain parts of the United States Constitution, then it allows them to ignore other parts of the Constitution, including, for example, our First Amendment right to free speech and our Second Amendment right to keep and bear arms. So with that said, I want to talk about, because we have to get a little geeky, and there's a lot of information out there in the press that I don't think is really correct, dealing with this decision by the U.S. Supreme Court today on an emergency basis, dealing with whether or not Donald Trump's administration has an obligation to comply with a federal district court TRO, temporary restraining order, telling them supposedly to pay billions and billions of dollars out the door to a bunch of programs approved by the USAID, which, as Elon Musk and Doge is proving, seem to have gone to a lot of left-wing organizations around the world and into the country. But again, we're not talking about the merits of the USAID here. I want to talk about what happened with the U.S. Supreme Court. And of course, there was a dissent today by 4 Supreme Court justices that were upset by what the Supreme Court itself did. And that dissent was by Justice Alito, signed off by Justice Thomas, Justice Gorsuch, and Justice Kavanaugh. So let me talk about this order and why I do not think we in the Trump movement, we in the conservative movement, we in the Second Amendment movement, we in the constitutionalist movement, whatever you want to call it, should not be freaking out just yet. I don't think it's a basis for doing so, although a lot of people are getting a lot of clicks today, as best I could tell, from saying exactly that. So let's cut to the chase. What's going on here? After Donald Trump deployed his Doge team and Elon Musk, they started looking at various agencies and where the money went. Follow the money. They went into the Treasury Department and noticed that in the USAID program, guess what? Billions and billions of dollars were going out the door all around the world to all sorts of crazy, crazy programs. And if you saw the quote-unquote State of the Union address, it wasn't technically the State of the Union, but it's kind of like the State of the Union address to the joint houses of Congress last night by President Trump. He talked about some of the craziness of where this money was going to. Now, what does this mean for what's going on today and what you need to know? That is this. After Donald Trump identified these issues, and I should say that the Doge team identified these issues, Donald Trump became aware of it, and he, as the executive branch head under Article 2 of the U.S. Constitution, basically ordered a pause on the payment of these funds so they could engage in a real review to see whether or not there was any fraud, corruption, problems, any other defenses to payment, any other things that needed to be looked at, because it was pretty apparent, according to the reporting, that whatever review that needed to occur to make sure these money going out the door was appropriate, it didn't seem like there maybe was as much of a review as should be. So with that said, Donald Trump basically issued an order on behalf of for the executive branch saying, don't pay any more money till we figure this out. Several organizations then brought a lawsuit, and this is going to be important, folks. They brought a lawsuit in the United States District Court for the District of Columbia. This is the same court system that, of course, was dealing with the Jack Smith issue and allowing Jack Smith to pursue Donald Trump. It was also the same court system in the District of Columbia that's controlled by the deep state, surrounded by the deep state, drinking the same water as the deep state. So you kind of know where the D.C. Court of Appeals, not the Court of Appeals so much, but the D.C. trial courts, you kind of know where they're going to come out on a lot of these anti-Trump questions and Trump issues. So this case was assigned to a judge, Amir Ali, in the U.S. District Court for the District of Columbia. And what he did was he entered a TR. Now, this is going to be very important. This is going to make you the smartest person in the room. Judge Ali entered a temporary restraining order. He actually entered 2 temporary restraining orders. What is a temporary restraining order? This is very important to understand this. A temporary restraining order is different than a preliminary injunction. A temporary restraining order is different than a preliminary injunction in a lot of material ways. A temporary restraining order is about an order that maintains the status quo at the very beginning of a case until you have a hearing over whether or not a preliminary injunction should be entered. So you start a case, you usually or often will seek a temporary restraining order, asking for the judge to maintain the status quo, pending the scheduling of and the hearing of a preliminary injunction. If you get a TRO, it's only good for like a week or 2. And this is very important, it is not appealable. Hear what I just said? A TRO or a temporary restraining order is not appealable as a general matter, which means if the judge tells you to do something, you can't appeal it. Now, the reason why this is okay usually is because TROs are very short in stay. They only last for a few days or a week or maybe 10 days. They're super duper short. And the only purpose of the TRO is to allow the parties to maintain the status quo until there is a preliminary injunction hearing that usually occurs 10 days to 14 days after the case is started is a general matter. And that's what happened in this case that we're talking about here and now, dealing with USAID, where people are seeking money from the federal government to be paid to their nonprofit organizations, allegedly for work that they had already performed. So what happened here now, this is where the game got played by this federal district court judge. And the truth is, Chief Justice John Roberts and the Supreme Court shut this game down, which was great. Great kudos for the Supreme Court. So what was the game that was played? Remember how I just said that a temporary restraining order is not appealable, but a preliminary injunction order is appealable. This is really important to understand, because what happened here was Judge Ali entered a restraining order, a TRO, telling the Trump administration to pay billions of dollars for work allegedly had already been performed in the context of this temporary restraining order. You hear what I just said? It was a TRO, temporary restraining order, that says, don't maintain the status quo, pay the money out the door from the U.S. Treasury to these nonprofit NGO groups. And the judge was slick because he did it in the context of a TRO, temporary restraining order, which means what? You know what I'm about to say. Because it was a TRO, the Trump administration did not have the legal right to appeal it, because you only have a right to appeal a preliminary injunction, not a TRO. So when this judge entered an order that says, on a TRO basis, pay the money, Donald Trump, to these groups, legally speaking, Trump was not legally allowed to appeal that. So what happened was, and this is where the Supreme Court deserves our kudos, is the Trump administration immediately sought an appeal of the TRO and said to the D.C. Court of Appeals, which was denied, and then the Supreme Court, the following. Look, we understand that we legally don't have a right to a TRO or to appeal a TRO, but this is crazy what's going on with this crazy district court judge. This is insane. He is telling us to pay billions of dollars, which we're not even capable of doing in this time frame. We can't even comply with the TRO, and it's absurd to think that the TRO has been entered in this way. And Chief Justice John Roberts basically agreed, because he entered an administrative stay which stopped the effectiveness of that TRO that says pay the money. See what happened? This was a win for the Trump administration, because the deadline under that TRO entered by Judge Ali to pay the money has, as of this moment in time, expired. It's moot. It's gone away as a TRO, temporary restraining order. So what's happening is this. The Supreme Court today denied the administrative stay that Trump sought on that TRO because it's moot. Because the deadline for Trump to pay that money to those USAID folks has come and gone. The TRO is moot. It's over. The deadline's come and gone. And the reason why it came and gone and the Trump administration did not get into legal trouble is because the Supreme Court, with Chief Justice John Roberts, granted the stay, and then the deadline expired. That was a huge win for the Trump administration, thanks to the United States Supreme Court slapping down that district court judge. Great news. So where is this big hubbub today coming from? Well, here's what's going on now. What the Supreme Court did today in an unsigned opinion that just lasted a paragraph basically said the following. They said, look, we're denying the administrative stay basically because it's unnecessary, right? The deadline is come and gone. So, and it goes on to say we've denied the administrative stay basically because it's not needed anymore. And then it goes on to say that we're sending this case back down to the district court in light of the fact there's going to be a preliminary injunction hearing. They reference the notion of a preliminary injunction in their Supreme Court order by the unsigned majority. That's significant because remember, the TRO is not appealable, but a preliminary injunction is. That is hugely important because it means when this case has gone back down to the district court, and by the way, tomorrow, I believe, is the date of the preliminary injunction hearing, which means that the Trump administration is going to be able to make all the arguments they previously made about why it's not appropriate to pay this money. Those have all been preserved and will all be made, presumably, in the context of the preliminary injunction hearing. And if Judge Ali, and I suspect he will, makes the same decision again in the context of a preliminary injunction and says, Donald Trump administration, pay all that money out the door to those third world NGOs or whatever it is for the work they allege they already did, that will be in the context of a preliminary injunction order, which is appealable as of right by the Trump administration. And then the Trump administration can then seek the appeal in the normal course, expedited, all the way up to the U.S. Supreme Court. So I think what's going on at the Supreme Court level is, as I've told you before, they work really hard every day, and it's going to sound weird, but listen carefully. They work really hard every day with all these crazy cases. Even the 70 cases they take a year, there's dozens and dozens of legal briefs with thousands of footnotes and arguments, and they have a lot of work to do. And I'm not making excuses for the Supreme Court. I'm just telling you the reality on the ground. They have a lot of work to do in the normal clause of figuring out which cases to take, why should they take the cases, who should win the cases, and then hearing the cases, hearing the oral arguments, preparing for the oral arguments, writing the opinions, and so on. It's a lot of work at the Supreme Court. It's not easy. The reason why I mention that in that context is whenever you get one of these emergency appeals, these emergency applications for an administrative stay or whatnot, it is totally distracting to the Supreme Court justices and their staff and their clerks. And it's not to say it's not justified or legitimate or illegal or anything. It's just as a practical matter, it's a pain in the butt. And rightly so, but it's very distracting to the Supreme Court. Now, the only reason why I mention that is this. I think the Supreme Court, the last thing they want to do, in addition to their current workload, is to open Pandora's box up to setting a precedent for everyone to start seeking emergency applications to the U.S. Supreme Court on the basis of TROs, which in the normal course are not appealable. So I have a feeling that one of the things going on here in today's decision that says rather we're going to enter an administrative stay to a TRO that basically is a moot point now is they are trying to say we don't want to get involved in the business of entering administrative stays and getting involved with whether or not a TRO should have been issued. Because we have enough headaches dealing with whether or not a preliminary injunction should have been entered, because there's a right to appeal from a preliminary injunction. There's no right to appeal from a TRO, which is generally speaking not appealable. Okay, so that I think is what's really going on here. This case is not, and remember, the money that's in dispute right now, today, right now, is sitting in the bank account of the U.S. Treasury. It has not gone out the door. It has not been ordered to go out the door, and it's not going out the door anytime soon. That will be decided in the context of this preliminary injunction hearing that's occurring tomorrow. And if there's a new order from Judge Ali to say, send the money out the door, Trump administration, you can bet your bottom dollar that those Trump lawyers are going to seek in the normal course an immediate appeal up the chain to the U.S. Supreme Court again, except this time it will come in the context of a preliminary injunction appeal, which is normal as opposed to where we were right now, up until now, was an emergency application arising from a temporary restraining order, which is not appealable. See the key difference? This is a big deal to the Supreme Court, and I think that's what's going on here. Now, I just want to make a couple observations why I think the Trump administration is going to ultimately prevail and not have to pay this money. We'll see if I'm right, for several reasons. First of all, listen carefully, folks. When you sue for money, it is a basic breach of when you're suing for money in this context for what is essentially a breach of contract case. In the federal system, if you're suing the federal government for money for what is equivalent of a breach of contract, you actually don't sue the federal government in the United States district courts. You sue the federal government in a different court, which we don't really talk about in the context of the Second Amendment because it doesn't really come up. But you sue the federal government for money for breach of contract in the United States Court of Federal Claims, which is the U.S. Court of Federal Claims is in Washington, D.C., in a very beautiful building near the White House. But that is where you sue the federal government. You do not sue the federal government in the U.S. district courts. You sue them in the U.S. Court of Federal Claims. So if you have like a takings case or an eminent domain case against the federal government or a breach of contract case, in a defense contractor case, you sue in the U.S. Court of Federal Claims, assuming the claim is more than like 10 grand or so, which obviously this is. So to the extent they're seeking money relief, they should be in the U.S. Court of Federal Claims, not in the United States District Court. This is what the dissent from Justice Alito points out, and he's absolutely correct. Beyond that, remember, to get injunctive relief, we've talked about this in other videos, you need to show that you're likely to succeed on the merits, number one, that there's going to be irreparable harm, like my constitutional rights will be violated, I can't get that back, and the balance of the equities and so on. Irreparable harm by definition means that I cannot be made whole by the payment of money. Hear what I just said? Irreparable harm by definition means you cannot be made whole by the payment of money. Here, these plaintiffs are claiming there's irreparable harm because they're not getting their money. But again, the remedy here is paying them money. And if they can be made whole by the payment of money, there's no irreparable harm under very basic temporary restraining order, preliminary injunction standards of likelihood of success on the merits, irreparable harm, balance of the equities, and public interest, right? The four elements that you all litigators know quite well, I'm sure. Beyond that, and this is very important, remember what happens when Donald Trump lost those judgments and had to post a money bond? He wanted to seek an appeal and post a bond in case it turned out that he lost, that money was money good for the people that had sued him for those damages and had won. Here's the thing. When you enter an injunction as a judge and you order the payment of money, which is highly unusual, but let's say you do that, guess what? You as a federal judge can require the recipient of that money, in this case, those NGOs, those nonprofits, whoever it is that's going to get the billions of dollars, you can enforce the plaintiffs in this case to post a large bond that if it turns out Donald Trump ultimately wins the case against them and they were not entitled to receive the money, the posting of the bond by those plaintiffs that are going to get this money, they will have to post a bond so that if Trump turns out that he paid the money wrongly, he gets his money back because the bond will reimburse the U.S. Treasury. Hear what I just said? And the payment of the bond and the acquisition of the bond is the burden of the people. In this case, the plaintiffs that want the money from the federal government. So certainly a federal judge should require these plaintiffs, if they're going to get this money, to post a bond that if Donald Trump turns out to have win the case, the bond will be for $2 or $3 billion and will be paid back to the United States Treasury. And if they don't post the bond, then they don't get paid the money. They don't get the benefit of that injunctive relief, because the purpose of posting a bond is if it turns out the injunctive relief was wrongly decided, was wrongly issued, the person that had to comply with the wrongly issued injunctive relief gets reimbursed with payment of the amount of that posted bond, which is just basically a promissory note with a lot of money attached that automatically pays off in the event it turns out the injunctive relief was wrongly or improvidently granted. All right, folks, so there you have it. Hope you learned a little bit something today about some of the things going on at the Supreme Court with this USAID case. I think there's going to be a lot more to the story as we move forward. I think it's all going to work out in favor of President Trump. It just take a little bit of time. But don't worry about the hysterical headlines. I don't think they're quite justified or precise enough in my view. So there you have it. Make sure you subscribe to the Four Boxes Diner on X at Four Boxes Diner. Don't forget to subscribe to this channel on Rumble and YouTube. Trying to get to 200,000 subscribers on YouTube. We're getting close. We're not there yet, but we're working hard at doing so. And I look forward to talking to all of you again very, very soon here at the Four Boxes Diner.
Orders up. Table 2A.